Hello, I'm Professor Kozlowski, and welcome to my webpage at George Mason University. You'll see a list of my courses that I teach, most of which are online televideo courses, and many of these courses, required readings, are taken from law review columns that I've written for the monthly Parks and Recreation magazine, which is the official publication of the National Recreation Park Association. I've been writing these articles since January of 1982, and on my webpage I have a link archiving most of these articles. And today we'll be taking a look at the article that was published in November of 2011 entitled Park Inversion Protection in the LWCF, which stands for Land and Water Conservation Fund, project map. So let's take a look at this particular case, and hopefully you'll get some idea of not only how Land and Water Conservation Fund Act works, but the legal significance of this particular piece of legislation. Very significant in terms of expanding the available public park and recreation opportunities. So as I mentioned, particular case involves park conversion protection in the LWCF project map. Let's take a look at the Land and Water Conservation Fund Act, which was enacted in 1965, and it can be found at Title 16 of the United States Code, starting at Section 4601-8. And over the years since its inception, LWCF has appropriated over $3.6 billion for more than 40,000 parks and recreation projects. The Land and Water Conservation Fund Act supports acquisition of open space for parklands or the development of outdoor recreation facilities in every U.S. county and almost all localities in the United States. Now, LWCF grants have to be matched 50 cents on the dollar. It's a 50-50 matching grant program, so the state or local contributions have to match the federal dollars. And this grant investment, since its inception, has totaled $7.2 billion. And LWCF projects, of the number, about 10,500 have helped states and localities acquire some 2.6 million acres of parkland. 29,000 projects have been for the development of outdoor recreation facilities. So whether you know it or not, in most instances in your local parks and recreation agencies, you may be benefiting from development funds provided by LWCF. In fact, at its inception in 1965, this provided a major impetus for the parks and recreation field, in which many parks and recreation agencies became much more active in planning and programming for public recreation. So 75% of the total funds obligated have gone to locally sponsored projects as opposed to state projects. And in so doing, LWCF has provided close to home recreation opportunities. Most folks will never get to see the crown jewels of the National Park Service, get to Yellowstone and Yosemite, but they certainly are able to take advantage of their local neighborhood parks. And oftentimes these parks were either acquired or developed, in many instances, with land and water funding. Problem, however, and is illustrated by the case we'll take a look at today, the Land and Water Conservation Fund legacy is under siege. And what's been acquired and developed through land and water conservation funds is constantly threatened and may be lost unless individual public citizens are vigilant, lost to unauthorized conversions. And oftentimes it's your own local government who would rather use these lands now, given economic development pressures and strained budgets, to use this land for other more lucrative economic development purposes and divert it from its existing public park and rec uses. And the Land and Water Conservation Fund Act, as we'll see, doesn't necessarily absolutely prevent it, but it provides some procedural roadblocks to at least make it a bit more difficult when the government, your own local government, decides to play fast and loose with these lands either acquired or developed through Land and Water Conservation Fund monies. So the lesson to be learned is that organizations and citizens groups must be vigilant and knowledgeable in LWCF law, and the fact that it even exists, in the regulations and process when a local public recreation resource is threatened by their own local government in the interests of oftentimes economic development. So the point being, under the LWCF Act, is to ensure that the state who receives these funds and the National Park Service, who oversees the Land and Water Conservation Fund Act, fulfill their contractual and legal obligation to protect LWCF projects which were acquired or developed for public outdoor recreation use and public outdoor recreation values, and these lands are supposed to be maintained for public outdoor recreation use in perpetuity. And as we'll see, you're knowledgeable of the process, the LWCF can provide to citizens groups, these neighborhood associations or friends of the parks groups, some procedural safeguards against the threat of conversion to another use, inconsistent with the terms of the original grant, whether it's for non-recreational use or even diverting it to a supposedly recreational use that's inconsistent with the terms of the original grant. So while now absolute, the Land and Water Conservation Fund Act law may provide some leverage, particularly to local park and recreation advocates, to challenge plans by their own local government to convert planned conversion of local park resources to something which is inconsistent with the values and terms of the original LWCF grant. And the major section that provides such leverage, and we'll see an illustration example of this, is section 6F. And this is a core compliance provision of the LWCF law. And this section of the law ensures that once a property is assisted, receives federal financial assistance through an LWCF grant, requires that it shall be preserved in perpetuity for public outdoor recreational use. This is not necessarily absolute. There's an exception. Or if it is converted, which the term is under section 6, it has to be replaced by a substitute property of equal value, usefulness, and location. Statutory language, express language, specifically provides that no property acquired or developed with assistance under this section shall, without the approval of the Secretary, this refers to the Secretary of the Interior, who in turn has delegated this responsibility, this oversight responsibility, to the National Park Service, that it shall not be converted to other than public outdoor recreational uses. Provides further that the Secretary of Interior, through the National Park Service, shall approve such conversion, but only upon such conditions as he deems necessary, once again to assure the substitution of other recreation properties of at least equal fair market value and of reasonably equivalent usefulness and location. And section 6 is codified at Title 16, which is the conservation title, Title 16 United States Code, at section 460L-8F3. So 6F3 refers to the section 6 of the initial law that was passed, but here's the code reference. Furthermore, fleshing out the requirements and details are the LWCF regulations regarding post-grant processes. And these can be found at Title 36 of the Code of Federal Regulations at Part 59. Specifically, Section 59.3c details the procedural steps of any conversion. That if a state wishes to designate a property for something other than public outdoor recreation, as defined under the terms of the original grant that provided federal assistance, 50-50 matching grants to acquire this property, that notwithstanding the investment by the federal government, the LWCF investment, that the state, if they're going to convert a property that was intended to remain public recreational, outdoor recreation use in perpetuity, that the state, who receives the grant funds from the federal government and then either keeps it for state projects or in most cases distributes it to localities or local projects, the state must evaluate all practical alternatives to any proposed conversion. And in so doing, the requirement to substitute properties of equal market value and recreational value, conversion regs require that the state determine the fair market values of the property to be converted and the replacement property, and satisfy the criteria for such replacement properties. Furthermore, proposed changes from one LWCF eligible use to another, changes to an other than public outdoor recreation use, So in one case, for example, money had been used to develop a park, and then there was a plan to convert that park to a golf course. That would be a conversion because it was not consistent with the terms of the initial grant, and you would have to go through the Section 6 conversion process. So when there's a change even to another recreational use that's not consistent with the context of the original LWCF grant agreement, that would be a conversion. So conversions aren't absolutely prohibited. It simply requires compliance with the Section 6F conversion procedures and regulations. And it requires the National Park Service, who acts on behalf of the Secretary of the Interior, that any approval of the substitution or replacement land be in accordance with the most important section, is Section 6F3. Now let's take a look at a case which illustrates the process. And here we have a local citizens group who is objecting to a proposed conversion, even though the local government and the Park Service, as we'll see, denied that in fact it was a conversion. Tried to play a little bit too fast and loose with these LWCF acquired and developed lands in the interest of economic development. This is the case of Brooklyn Heights Association versus the National Park Service. It's a federal district court case from the Eastern District of New York, and the decision was issued on July 11th, 2011. And here, BHA, the Brooklyn Heights Association, alleged the National Park Service had violated Section 6F3 of the LWCF in, quote, revising the original LWCF project map, changing in their minds the terms of the original grant to suit their purposes. And this proposed change, revision, was more than 5 years after LWCF State grant had been awarded to develop a state park. And in so doing, this proposed revision effectively removed the historic structures, which included a tobacco warehouse and Empire stores, from the procedural requirements and safeguards under Section 6F3 of the Land and Water Conservation Fund Act. So the allegation was that Park Service, in order to go along to get along with the city of New York here in New York State, were really playing a little fast and loose with the law. The facts of the case: Fulton Ferry State Park, established in 1978 and completed in 87 by the New York State Office of Parks, Recreation, and Historic Preservation. 2001 Land and Water Conservation Fund project map for the park included the tobacco warehouse and Empire stores. These historic structures were built in the 1860s. And the original LWCF project included, and there's a contract between the state and the federal government. The original contract agreement included a property described in the boundary map would be maintained in public outdoor recreation use in perpetuity, consistent with the legislative intent, express statutory language of the Land and Water Conservation Fund Act. And in the contract, echoing the legal requirements, that the project should not be converted to other than public outdoor rec use without the approval of the Secretary of Interior. Now, the State Office of Park, Recreation, and Historic Preservation has now acknowledged that the description of the boundary 6F boundary stated in the original LWCF project agreement included the tobacco warehouse and the Empire stores. And that at the time, 2002, the tobacco warehouse and the Empire stores were being used for public outdoor rec use. That the State Office of Park, Recreation, and Historic Preservation began allowing third-party groups to hold special events or public programming at the tobacco warehouse. And that the State Office began using Empire stores to house its administrative offices for the state park, as well as public restrooms for the park. In 2003, the Park Service acknowledged receipt of a final closeout document for the LWCF grant in the final amount, federal assistance, of $274,525. At the time may have sounded like a good deal, but when that land becomes valuable and there's economic pressures, and they might want to change their mind, but the whole purpose of the Land and Water Conservation Fund Act assistance is to retain these federally funded public recreation resources in perpetuity. Park Service in this case noted a review of the closeout material was found the project was in compliance with the Land and Water Conservation Program requirements, and at the time of closeout, as stated, it included the tobacco warehouse and the Empire stores. So now, years later, it's being challenged by the Brooklyn Heights Association. The city and the state want the Park Service to allow a, quote, revision of the project map. 2008, years after closeout, State Office of Park, Recreation, and Historic Preservation requested the Park Service to revise this 6F boundary map for the state park, and in so doing, OPRHP wanted, because they claimed difficulties associated with portions of the park that included buildings that do not have an outdoor recreational component. They had their eyes on these historic structures. It may have been more lucrative to use these historic properties and cut some deal with a private developer and devote them to other uses inconsistent with the terms of the original grant. In the Office of Park, Recreation, and Historic Preservation, the State Office found 4 existing former warehouse buildings in the southern side of the park they claim were not suitable for nor used by the public for outdoor recreational opportunities in the park, which is contrary to the facts at the time of closeout that outside groups were indeed using, particularly the tobacco warehouse, for public recreation events. So the Office of Park, Recreation, and Historic Preservation, however, maintained that a, quote, revised 6F3 boundary map for the state park, which would exclude the tobacco warehouse and the Empire stores from the LWCF protected boundary, would, quote, not adversely impact the utility and viability of the remaining parkland, and then would allow them to cut some sort of deal with private developers for these historic properties for commercial uses. And even the Park Service here noted LWCF regulations do not normally allow for the realignment of a 6F boundary after a project has been administratively and financially closed, which it had been here for 5 years. And in this spirit of the Park Service typically to get along with local governments in the state, unless they're called to task by outside advocates, citizens groups here like the Brooklyn Heights Association. Park Service here found the pre-existing warehouses should have been excluded because the LWCF program does not provide assistance for existing or proposed, quote, indoor recreational facilities, and these former warehouses were not suitable for recreational use by the public, even though they were being used by the public. And the interesting part, doing a little research, the tobacco warehouse has an exterior, but it's not covered by a roof at the time. Despite this, Park Service granted the state agency's request to, quote, revise the legal 6F boundary map for the project, because they claimed more or less a technical clerical error that both Park Service and the Office of Park and Recreation and Historic Preservation for the state of New York had inadvertently overlooked the existence of the 4 warehouse buildings located within the project boundary. And as a result, 2010, the Office of Park and Recreation and Historic Preservation conveyed the title the state park to the Brooklyn Bridge Park Development Corporation, which was a subsidiary of the New York State-owned Empire State Development Corporation, to develop a larger Brooklyn Bridge Park. And this agreement conveyed the tobacco warehouse and the Empire stores based upon the revised 6F boundary map approved by the Park Service, which cut out the tobacco warehouse and the Empire stores from the project map, in which they were included in the original grant that closed out 5 years earlier, and provided 99-year ground lease to the Development Corporation, BBPC. 2010, plaintiff Brooklyn Heights Association requested the Park Service to reverse its determination, which had allowed the exclusion of the warehouse properties in this revised boundary map without going through the required 6F process for any conversion. 2011, in response to Brooklyn Heights Association requests, Park Service reviewed its decision to approve what they termed a technical correction to the Section 6F boundary for the state park. And in so doing, Park Service noted that regional staff have approved limited, quote, technical corrections to the 6F boundary, where they determined that there was in fact a significant mistake in how the boundary was mapped. So indeed, is this just a technical correction, a mistake, if you will, or is it an attempted end run? In fact, it is a conversion which requires compliance with the conversion procedures under 6F. And the Park Service noted that typical reasons for excluding a portion of a public park or recreation area from 6F protection, designed to prevent conversions, include private or commercial development, which, LWCF is supposed to protect the resources against this sort of exploitation. Or they noted are pre-existing buildings or structures with plans or uses not allowable in Section 6F areas. That yes, LWCF is only for public outdoor recreation purposes and can't be used to develop or acquire indoor facilities, but within the overall project there can certainly be, as we'll see, buildings and structures which do not necessarily take an otherwise outdoor rec use and make it indoor, outside the parameters of LWCF. Now, in the opinion of the National Park Service, they found it was, quote, clear at the time of the National Park Service approval of the state's application for federal assistance, November 30th, 2001, 5 years prior to the situation, that the tobacco warehouse was not suitable for public outdoor recreation use, and no plans were included in the LWCF application. But it was included in the project map at the time that the grant was finally closed. So as a result, consistent with the desires of the state agency here, Park Service concluded, quote, the inclusion of the Empire stores and the tobacco warehouse within the Section 6F boundary was a, quote, correctable mistake, as if it was a mere clerical error and that could be excised out of the project map without going through the conversion requirements that, keeping in mind, would require substitution of properties of equal market value and recreational value. Given the fact that these are historic properties and obviously being looked upon as valuable for economic development, that may indeed make it a deal breaker if 6F kicks in. The Park Service agreed with the state. The state never intended, prior to the grant completion, to commit to use the tobacco warehouse solely for public outdoor recreation, although it was, as we noted, being used by third-party groups for public recreational use. And to qualify as public recreational use under the Land and Water Conservation Fund Act, would it necessary that a structure be used exclusively for public recreation use? And clearly that's not the case, because on any site project you're going to have ancillary structures for administrative purposes or maintenance buildings and alike. So the issue here was whether any alteration or construction in connection with tobacco warehouse and Empire stores, use them for some sort of economic development, whether indeed that triggered the Section 6F3 conversion requirements of the Land and Water Conservation Fund Act. And the role of the courts in looking at challenges to governmental actions, they'll apply the standards of the Administrative Procedure Act, APA. This is the procedural vehicle, oftentimes by which citizens use to challenge governmental actions. So that under the Administrative Procedure Act, the standard of judicial review, as we'll see, is rather deferential to agency action, but it's not a rubber stamp. And in reviewing federal court, reviewing a governmental action, should hold unlawful and set aside agency action found to be not in accordance with law. The question is, is this action not in accordance with the Land and Water Conservation Fund Act, namely Section 6F, or without observance of procedure required by law? The procedural requirements of Section 6F, where the Secretary is required to make a finding, if it is indeed a conversion, whether there's substituted properties of equal market value and recreational value. Administrative Procedure Act is found under Title V of the United States Code here at Section 706. So as noted, the APA standard of judicial review, courts won't substitute their judgment for that of the agency, particularly in areas that are left to the expertise of the agency. And certainly the Park Service would know more about recreation properties than judges. So it's generally deferential to agency determinations, particularly in areas of agency expertise. But once again, it's not a rubber stamp. So under APA review, the federal courts must be certain that an agency has considered all the important aspects of the issue and articulated a satisfactory explanation for its action, including a rational connection between the facts found and the choice made. So the choice here is that the Section 6F conversion procedures weren't necessary because there was a technical or clerical error, that these properties, which had been included in the original project map that was closed out 5 years earlier, that somehow they shouldn't have been there, that it was a mere clerical, technical mistake, oversight. So it should not require 6F review. And under the Administrative Procedure Act, APA review, the federal court would determine whether the agency's action was based here on a permissible construction of the LWCF statute, in effectively ignoring 6F procedures. If indeed this is a conversion of the project in some way, shape, or form, where properties that were used for, in part, public recreational use are now changed to some other use, if indeed that is a conversion, then Section 6F would have to be complied with. In so doing, the federal court would also determine whether the Park Service had adhered to its own regulations in implementing Section 6F. We saw a reference earlier in the Code of Federal Regulation to the conversion requirements. Once again, courts will not second guess the agency's determination. It's deferential review under the APA. So an agency's interpretations of its own regulations, like the laws it administers, is entitled to substantial deference by the court unless it is plainly erroneous or inconsistent with the regulation. Applying that standard of review here under the Administrative Procedure Act, Federal District Court found that there was no dispute that the Park Service here did not follow the conversion process laid out in Section 6F. None of these facts should it have done so. So in 2008-2011, when deciding that the, quote, revision of the original 6F boundary map for the project was simply the correction of a mistake, and that they agreed and went along with the state agency that the State Office of Park and Recreation and Historic Preservation never intended to include the Tobacco Warehouse and Empire stores on the map when it applied and subsequently closed out the LWCF grant. So during this whole process, these properties were on the project, had been used for public rec use and now they want to effectively excise them from the project without going through the 6F conversion requirements. So while deferential to the agency's judgment, federal district court here rejected the claim that the state of New York Office of Park Recreation Historic Preservation's mistake in its original boundary designation. And looking at the administrative record of the original grant, the documentation, the contract between the state, federal government, the Park Service here, the court found the Section 6F boundary map submitted by the state under the original grant terms that got the federal financial assistance and accepted by the Park Service at the time did not contain not the slightest hint of any mistake that needed correction. The court, in so doing, found no suggestion of a cartographical or mapping error or any kind of inadvertent ministerial or clerical oversight. So this is not merely technical or clerical. This is a change. And we'll see any change to the parameters of that original project triggers the conversion requirements. The court noted the purposeful inclusion and acceptance of these historic structures within the original 6F boundary map had included the tobacco warehouse and Empire stores on that original boundary map. And while the Park Service had argued that this was merely a correction requested by the state, we didn't mean to include that in the original map. It was behind the scenes. Well, now we've got an economic opportunity to put these properties to other uses, and if we're required to in fact substitute properties of equal recreational and market value, it may once again be a deal breaker. So walks like a duck, talks like a duck. It's a conversion here. There's a change. Because the Park Service here went along with the state agency that these structures were not suitable or intended for public rec uses, even though they had been used for such by third parties at the time of the grant, and therefore should not have been included in the boundary because they were, quote, indoor recreation facilities, and acquisition and development of properties for public rec use under the Land and Water Conservation Fund Act are indeed limited to public outdoor recreation uses. But within the larger parameters of a project, this could certainly still include indoor structures. So while being deferential to agency determinations under the Administrative Procedure Act standard for judicial review, the federal district court here found that it was unlikely that the Park Service's interpretation of that language is based on a permissible construction of the statute, because in so doing it would effectively allow an end run around the whole idea of federal funding to states and localities under the Land and Water Conservation Fund Act to ensure that properties acquired and developed under the Act are retained for public recreation use in perpetuity. In any change which would constitute a conversion, you have to look at alternatives, try to avoid changing such properties, and or providing properties of equal market value and equal public recreational use value. So the court here noted, in order to affect the intent of the act, the public outdoor rec uses within the context of Section 6F, what would constitute a conversion, triggering the procedural requirements, are to be interpreted broadly and to encompass uses not involving the public's actual physical presence on the property. That there may indeed be facilities in which the public does not use actively for public recreational use, but they're necessary part of the larger project for a whole number of purposes, including administrative offices or storage or maintenance, things of that nature. So the federal district court, while being deferential, they found it particularly troubling that the Park Service simply accepted the state agency's request and determination, accepting it on its face value and not questioning it in any way. The New York State Office of Park, Recreation, and Historic Preservation, their bare assertion that now, more than 5 years later, that these historic properties were suddenly an assertion of unsuitability. And the Park Service, in allowing this, agreeing with the state, simply regurgitated the state agency's, quote, revisionist finding of its own, being revised because now it's more economically advantageous to allow private development of these historic sites and not have to deal with the conversion requirements if they can be effectively cut out of the original map, which was the basis for the grant in the first place. And in looking for some sort of evidence in order to support the agency's determination under APA review, the court here has based its decision on an invisible record and a sweeping action that entirely failed to consider an important aspect of the problem. Namely, in the real backbone, the guts of the Land and Water Conservation Fund Act, is the vital importance of 6F protection for LWCF assisted property. Because without such protection, then the funding, federal funding for these properties, acquiring properties or developing them for public recreation use, be simply illusory. As soon as it becomes more advantageous to convert these properties to other uses for economic benefits, then they would be converted. So as a result, the federal district court here found Park Service had acted contrary to the statutory provisions of the Land and Water Conservation Fund Act and the regulations, as we looked at earlier, that govern its application. So doing, the court noted that Park Service's own regulations make it clear that a 6F boundary map, including the original grant, may protect properties, including not only the tobacco warehouse, but also Empire stores. And these stores included the state agency's office space and public restrooms. So they were supportive structures to the overall park project. And that alone, just because their buildings did not make them indoor rec facilities or non-rec facilities that were supposedly ineligible on their own for land and water funding, so therefore they shouldn't have been part of the project. That's sort of the mental gymnastics that the state agency went through to get what try to get what they wanted, and the Park Service is typical, as I mentioned, simply unless challenged, we're going along to get along. So that support or assure the protection of public outdoor rec property, those facilities are needed without actually being used for public outdoor recreation themselves. They're still included. In referring to the Park Service's own regulations at Title 36 Code of Federal Regulations at Section 59, we saw referenced earlier, that post-completion responsibilities, the regulations apply to each area or facility for which Land and Water Conservation Fund assistance is obtained. The entire project, everything on the original approved project map, within the grant, what was the deal, the contract between the state and the federal government. And looking at the Park Service's own manual for implementing the Land and Water Conservation Act, so you got three levels here. You got the statutory law, the regulations, and then their own internal procedures, their operations manual, if you will. Court noted also allows LWCF assistance for certain eligible support facilities that are needed by the public for public outdoor recreation use of an area. And they mention restroom buildings or maintenance building, administrative offices and the like would also qualify. So facilities is stated in the agency's own manual that support the operation and maintenance of the recreation resource are included. They wouldn't be excluded because they're characterized as not being actually engaged in public outdoor rec use, or somehow they'd be, quote, indoor rec facilities not eligible for LWCF assistance. That's too narrow a reading of the law, and that's what the state's trying to push, and the Park Service agreed to exclude these historic properties from Section 6F protection. So as a result, the federal district court here concluded that the Park Service's decision was contrary to its own regulations, which demonstrably support the position that the tobacco warehouse and the Empire stores were properly placed on the 6F boundary map in the first place. And as a result, if you're going to change that, it's not a mere technical or clerical error. The court found any change to that map, removing them, constitutes a conversion. And conversions are not prohibited under the Land and Water Conservation Act, Section 6F, but it triggers the findings that have to be made by the Secretary of the Interior. That if any property is converted, there has to be property substituted, once again, of equal market value and recreational value. And it requires New York to consider alternatives and to provide substitute parkland if you're going to take the tobacco warehouse and the Empire stores, consistent with, as we've seen earlier, the legal requirements of Section 6F. Moreover, the federal district court noted that there's no regulations under the Land and Water Conservation Act, under those conversion regulations, that have an allowance for any, quote, revision or correction to a boundary map for technical reasons, clerical errors, if you will, other than by going through the conversion process. In addition, the Federal District Court found that the agency's their own LWCF manual, their operations manual, express language provided no changes may be made to a 6F boundary after final reimbursement, and this project was closed 5 years before this request was made, unless the project is amended as a result of what? Park NPS approved conversion under the 6F requirements. Because this assures the whole purpose that once an area has been funded with LWCF assistance, it is continually maintained in public rec use. That the local government, when they see a business opportunity, some money to be made, they can't suddenly sort of change their mind, and now what seemed like a good deal years earlier to get $275,000 of federal money, now there's more money to be made by playing fast and loose with these requirements and allowing these historic properties to be developed for an economic revitalization project or what have you. Not saying it can't be done, but it's going to be a higher price tag that you have to provide properties of equal market value and recreational value. So no conversion unless Park Service approves substitution property reasonably equivalent usefulness and location and at least equal fair market value. That's under the post-completion regulations at Title 36 Code of Federal Regulations, Section 59. And you can see with these historic properties and their location, that's going to be pretty hard to do. And in fact, if you did some research, we've got these properties are still included in the overall park project. So the manual, Park Service's own manual, specified what area must be covered in a 6F boundary map. And at a minimum, the agency's own manual stated that a Section 6F boundary map must encompass a viable public outdoor recreation area that is capable of being self-sustaining without reliance upon adjoining or additional areas not identified in the scope of the project. And presumably, if the Empire Store's Tobacco Warehouse are cut out of the project, the continued viability of the rest of the park would then be relying on these now mischaracterized outside properties. So the manual goes on to state that Section 6F protection will be the park, open space, or recreation area being developed or expanded, which the original grant and map included the Tobacco Warehouse, the Empire Stores. So as a result, Federal District Court held any map change after the close of a grant. So there was a 5-year time lag between the request and when the grant was closed, requires adherence to the ordinary conversion process mandated by both the statute, the law, and regulation. Circumvention of the statutory regime for the sake of expedience or otherwise, more money to be made by devoting these historic properties to an economic development project, would effectively eviscerate the whole purpose of the act. The taxpayer, federal government, wouldn't be getting what they had paid for the original grant, that $275,000, that it would deprive the public of what Congress intended it to have. Replacement property of equal value to any property removed from a Section F boundary map after the close of a grant. So the court concluded that the Park Service's interpretation of Land and Water Conservation Fund, although the federal district court would be deferred to agencies, it's a deferential view under the Administrative Procedure Act. Under these facts, the court found allowing to excise properties from a final 6F map after the close of a grant, if they are later deemed unsuitable or not intended for public outdoor rec use, the court concluded is flatly impermissible and directly contrary to established law. So as a result, the court vacated and declared void Park Service's decision, going along with the state request, to revise the final 6F map for an otherwise closed grant. And the court therefore remanded, sent back this matter to the Park Service for further administrative proceedings, requiring them to engage in the required 6F conversion process. The Secretary of the Interior, through the Park Service, shall, as we saw, make a determination, which would include the consideration of these properties that would be converted of substitute properties of equal market value and public recreation value. As I said, in a circumstance in this case, that would be pretty hard to do. So the court noted that Park Service could legally delete the tobacco warehouse and Empire stores from the original 6F boundary map, but in order to do so, rather than blow it off as a technical clerical error, they would be required to comply with the Section 6F conversion procedures we outlined earlier. So the outcome here, the court noted, doesn't necessarily mean that these properties would not be converted to other uses. So under 6F, it would not forbid excision, cutting out these historic structures from the map, either now or at some future date as a matter of federal law under the Land and Water Conservation Fund Act. It simply requires that the federal government, here the Park Service, keep its promise, which is embodied in the legislative intent, the Land and Water Conservation Act. Namely, that any parkland developed or improved with federal taxpayers' money under these 50-50 grants to the states, the Land and Water Conservation Fund, will remain available for public use in perpetuity. Or, at the very least, if they are to be replaced, converted, that they be replaced with substitute parkland of equal or greater value in terms of not only market value but public recreation value. And the court stated that's a promise that must be kept, and it's embodied in the real guts, the teeth of the Land and Water Conservation Act, is this Section 6F process. That being said, there's ongoing concern, number of media reports, that indeed a lot of these properties that have been acquired and developed in part with Land and Water Conservation Fund monies are being diverted by the local governments, that they're sort of playing fast and loose and ignoring the legal requirements. And unless they're called to task because the Park Service is underfunded and do not have the resources to be constantly monitoring these situations, and there is a tendency, as we've seen, for the Park Service kind of go along to get along with the states and local governments, unless you have advocates like the Brooklyn Heights Association that are vigilant, know how the process works, or even aware of the Section 6F requirements of the Land and Water Conservation Fund Act, and have the not only knowledge but the resources, both human and financial, to bring a challenge, then unfortunately, as I said at the outset, the legacy of the Land and Water Conservation Fund, which is significant, is under siege, and over time it seems like it's being gradually chipped away as the desire to put these open spaces and recreational lands to other more economically beneficial, quote, uses, that will continue. So hopefully you get an idea, and if there is a park that's suddenly being converted or changed to other purposes, there's a way on the Park Service website to check and see whether indeed that particular site at one time had ever been the recipient of Land and Water Conservation funds. And if indeed it has, then if it's going to be converted, not entirely, but even just a little portion of it, then the Park Service has to go through the conversion procedures. In my own experience, it was a highway widening project. The original plan was going to take 56 acres off the front of a large park. And doing some research, found out that indeed this particular park, Burke Lake Park, had been funded back in 1968 for, I think it was $80,000 for the campgrounds there. And I wrote a letter for the Virginia Department of Transportation reminding them that indeed there was land and water money here, and that if they were going to take some of the park for the widening of the Route 123, they had to comply with Section 6F. And I was told, well, this is just an alignment line on a map, and we haven't finally decided yet. And eventually that line was moved away from the park, and they wound up using eminent domain to take private property on the other side and paying homeowners and property owners there fair market value or more than fair market value to take the property, which in a way would be quicker and cheaper, because with the parkland you not only have to pay fair market value as you would in eminent domain, but also provide lands of equal substitute value in terms of public recreation. So there was, I mean, I certainly didn't have the wherewithal to go into federal court, but just to show that people are aware and are vigilant in watching when the Department of Transportation or the city decides to play fast and loose with parklands, that the city says, well, we own them. Yeah, but if there's land and water money involved in that property, there are strings attached, and 6F would kick in. So hopefully that gives you an idea of how this very important law has worked in providing many of the public parklands and recreational opportunities that we enjoy today, and how we can ensure that they do indeed remain available for public recreation use in perpetuity. And that concludes our discussion in this case. I'm Jim Kozlowski. We'll see you next time.